Welcome to The Explainer. Now, if you're studying for the bar or maybe you're a junior solicitor in Australia, you're going to want to listen up. Today, we are breaking down a masterclass on one of the most critical documents you will ever draft, the affidavit. This is really the art and science of getting it right, and we're taking it straight from a barrister's playbook. Okay, so let's just dive right in with a quote from Brisbane barrister A.J.H. Morris that really cuts to the core of this whole thing. We spend so much time learning how to draft pleadings, but he makes the case that an affidavit, that can be far, far more critical. And the reason why reveals this fundamental and frankly dangerous difference between the two documents. And here is that massive difference. Pleadings are, well, they're a moving target. If you get something wrong, you can usually amend them. But an affidavit? Oh, that is set in stone. It is a permanent record of your client's evidence under oath. A flawed affidavit can't be fixed. And what's worse, it becomes this devastating weapon for your opponent to use in cross-examination at trial. It's literally a trap waiting to be sprung on your own witness. So, getting it right the first time is completely non-negotiable. And that all starts with the absolute foundation of it all, truthfulness. I know, it sounds obvious, right? But this is where some of the most common and dangerous traps are actually hiding. First up, your deponent says something like they are authorized to make the affidavit. Don't you dare just take their word for it. Is that authority express? Has it actually been given? If they're making it on behalf of a company, for instance, you can't just assume a director has that power. The really prudent move here is to get a board resolution confirming it. Verifying this is your job. Next, let's talk about the so-called formalities. Things like taking an oath, making an affirmation, executing the document in front of a JP or a solicitor. These are not some quaint, optional traditions. They are fundamental, non-negotiable requirements. An affidavit that isn't executed properly is inadmissible. It's basically worthless. And a solicitor who knowingly files one, well, they're just asking for disciplinary action. Oh, and this is a big one. For every single paragraph, you have to ask yourself and the deponent this one question. Can you positively swear to this from your own personal knowledge? Not what you think happened, not what someone else told you, but what you actually know. If the answer's no, it doesn't go in. It's as simple as that. So what happens when the evidence isn't from personal knowledge? Well, in some situations, like interlocutory applications, you've got a little leeway, but the hearsay exception isn't a free-for-all. You have to state the source. And saying something vague like, I am informed by my solicitors, is completely inadequate. Useless. You need to name the specific person or the specific document. And crucially, the deponent has to genuinely believe it's true. If they have any doubts, they cannot swear to it. Okay, so we've covered truthfulness. But let's not forget, an affidavit is sworn evidence. And that means it has to comply with the rules of evidence. This is an area where, trust me, even experienced practitioners can easily slip up. First, the secondary evidence rule. You can't just describe what a letter says or paraphrase a document in the affidavit. You've got to exhibit a copy of the document itself. The only time you can get away with describing its contents is if the original is lost or unavailable. And even then, you better explain why you can't produce it. Bottom line, show the court the evidence, don't just tell them about it. And here is a classic error. The affidavit starts making legal arguments, sometimes even using phrases like, I submit that. No. An affidavit is for facts and facts only. The submissions, the arguments, the whole why we should win part, that is the job for counsel at the hearing. Keep it out of the affidavit, it's strictly inadmissible, and it just makes your evidence look weak. And finally, relevance. Look, this isn't just about keeping things neat and tidy. It's a huge tactical consideration. Every single irrelevant piece of information you include is basically a gift to your opponent. You're giving them a sneak peek of your case, your strategy, and a whole lot of potential ammunition for cross-examination. Keep your powder dry. Only include what is strictly relevant to the application at hand. All right, so we know what evidence to include and what to leave out. But how do we actually express those facts? This is where the craft of drafting comes in. What turns correct information into a clear, persuasive, and professional document? This brings us to a really simple but incredibly powerful principle. Forget this idea that legal writing has to be dense and complicated to be effective. As the source material points out, clarity almost always comes from simplicity. We're talking short words, short sentences, common constructions. Your goal is to be understood instantly, not to sound like you've swallowed a dusty law book. And this means we've got to cut out all the legal folklore, those traditional phrases that hang around without any real legal basis. You don't verily believe, you just believe. A document is a copy, not a true copy. And please, for the love of all that is holy, drop the "I crave leave to refer to." It's redundant nonsense. Just write like a modern professional, not like a Victorian clerk. So, what about structure? Well, the guiding principle here could not be simpler. The only logical order is chronological order. Tell the story as it happened, from beginning to end. Don't jump around. A court needs to understand the sequence of events, and a chronological narrative is the clearest way you can do that. You should only ever break this rule if you have an exceptionally good reason. Okay, let's bring this all home. Section 4 is all about your duty as a practitioner. It's about the final checks you absolutely must perform and the professional responsibility that rests squarely on your shoulders. This all comes together in a final 4-step check. Think of it as your pre-flight inspection before this document ever leaves your desk. Step 1, identify the facts the deponent can personally swear to. Step 2, filter those for admissibility and relevance. Step 3, write them down clearly and chronologically. And Step 4, make sure it all complies with the specific rules of court. You do this every single time. And why do we do all this? To avoid this exact moment. This is the absolute nightmare scenario for any advocate. Your witness is in the box, they're under cross-examination, and they say, "Actually, that's not quite right." Or even worse, "I didn't read it that carefully at the time." It just destroys their credibility, it destroys your case, and it destroys your own professional standing. And that brings us to the ultimate point. The responsibility for the affidavit's accuracy is yours. It is not good enough to just hand a draft to your client and say, "Hey, check this for me." You have a duty to the court to present accurate evidence. You have a duty to your client to protect them. And you have a duty to yourself to uphold your professional standards. You are the final gatekeeper of that document's integrity. So as you head to the bar or even just back to your desk to draft your next one, ask yourself this question every single time. Is this document a powerful weapon for my case, or have I just handed my opponent the ammunition they need to win? The choice and the responsibility is yours.